Hey everyone, my name is Cliff Kirsch, and I'd like to welcome you to the Eversheds Sutherland Webcast Advisors Act Regulatory Series third quarter update. We apologize for the delay in starting and the technical difficulties, but thanks everyone for sticking with us. I'm joined today by my colleagues in the U.S., Michael Koffler, Issa, Hanna, and Ben Marzouk, and also our UK colleague, Hanna Jones. And this program is the latest in our quarterly series of complimentary webcasts dedicated to issues affecting investment advisors. Before we begin, a few housekeeping notes. Number one, if you'd like to receive CLE credit for the webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And also, if you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. And also, if you'd like a copy of today's slide deck, you could download it from the viewing console, or as always, you could feel free to contact any one of us, and we'd be happy to send you a copy. So we have a lot to cover, and we're going to look at the SEC's guidance on proxy voting responsibility for investment advisors, some enforcement actions that are critical, SEC's OCIE risk alert, and more as we do these, we see the OCIE group really impacting advisor regulatory developments through these risk alerts. And we have ones dealing with disciplinary history and principal and agency cross-trading. And again, from our UK colleague, an update on the FCA's asset management market study. So what we try to do with these webcasts is keep you current on a quarterly basis. We don't call out the Form CRS and the fiduciary interp, and obviously that's still dominating everyone's thinking, and a lot's going into planning for in terms of CRS June 30th. We've covered those in the past, and we'll continue to cover it and note new developments regarding the CRS and related developments as FAQs come out and the like. But again, for today, we have what I reviewed on the agenda. So with that, I'm going to turn it over to Issa Hanna to go over the proxy voting guidance that the SEC released.
Great. Thank you, Cliff, and thank you all again for being with us today and for your patience in getting started. So earlier this fall, or I guess maybe the latter half of the summer, the SEC came out with new guidance for SEC-registered investment advisors that they can look to when determining how they can meet their fiduciary obligations when voting proxies for their advisory clients. The guidance came out on August 21st, 2019, following a 3-2 vote, and was published in the Federal Register on September 10th, 2019. The guidance is divided into 6 questions and answers and illustrates how an investment advisor's proxy voting responsibilities would apply in 2 different contexts. The first, where the investment advisor takes on sole responsibility for voting any proxies, and the second, where the investment advisor hires a proxy advisory firm to vote some or all proxies. Importantly, the SEC encourages investment advisors and proxy advisory firms to review their policies and procedures before next year's proxy season to ensure they're consistent with the guidance. So, in a lot of ways, the guidance is similar to the guidance that the SEC recently issued with respect to the investment advisor fiduciary duty and the solely incidental prong of the broker-dealer exclusion. That is, it was effective upon publication in the Federal Register, which again was September 10th, 2019, and firms should look at it immediately with a view to correcting any identified deficiencies as soon as possible. So moving into the 6 questions that the SEC went into to illustrate how the investment advisor fiduciary duty plays out in the context of proxy voting, we've listed all 6 of them here, and I thought I would just provide an overview with respect to each of these pieces of FAQ guidance, just at a high level. So the first question asks how an investment advisor and its client, in establishing their relationship, can agree upon the scope of the investment advisor's authority and responsibilities to vote proxies on behalf of that client. So what the SEC says with respect to this question is that as an initial matter and consistent with the general concept that an investment advisor's fiduciary duty follows the contours of the relationship agreed to by the investment advisor and its client. The SEC makes clear that an investment advisor is not required to accept the authority to vote client securities, and if it does accept the authority, the scope of any voting arrangements can vary. The SEC then provides a non-exhaustive list of examples of possible voting arrangements an investment advisor and client may agree to, subject to full and fair disclosure and informed consent. The overall theme here is that advisors have flexibility provided they meet their overarching fiduciary responsibilities. So the second question that the SEC tackled was, how can an investment advisor demonstrate that determinations are being made in the client's best interest and in accordance with proxy voting policies and procedures? So on this one, essentially the SEC's guidance is that each client should receive individualized treatment, and advisors must undertake appropriate diligence to determine what is in the best interest of each particular client when voting proxies. The guidance suggests that investment advisors conduct a reasonable investigation into the matters that the investment advisor may vote on behalf of its client to form a belief that its voting determinations are in the best interest of the client. The SEC explains in the guidance that a uniform voting policy may not be in accordance with the best interest of all clients, some of which may be institutional clients and others of which may be retail clients, and suggests that investment advisors consider whether to implement different voting policies for some of their clients, depending on the investment strategy and objectives of each client. Where an advisor retains a proxy advisory firm in any capacity, the SEC suggests the implementation of quality control and auditing measures to ensure that each client's proxies are being voted in their particular client's best interests. Turning to the third FAQ, what should an investment advisor consider when looking to retain or continue to retain a proxy advisory firm to assist in the proxy voting process? The SEC says here that advisors should consider a number of factors, including the capacity and competency of the proxy advisory firm to adequately analyze the matters in which the advisor is responsible for voting, the adequacy and quality of the proxy advisory firm's staffing, personnel, and technology, the proxy advisory firm's processes related to proxy voting policies, methodologies, and peer group constructions, and whether proxy advisory firm policies and procedures set forth sufficient requirements to identify and address conflicts of interest. So moving on to the fourth question here. What should an investment advisor do when it discovers that a factual error, incompleteness, or methodological weakness may materially impact one or more of its voting recommendations? In this regard, the SEC states that advisors should have policies and procedures in place that require periodic review of voting recommendations that includes an assessment of the extent to which factual errors, incompleteness, or methodological weakness materially affected any recommendations. Then the SEC says that to the extent that an advisor engages a proxy advisory firm to protect against recommendations based on factual errors, incompleteness, or methodological weaknesses, the SEC instructs firms to consider how effective the proxy advisory firm's policies and procedures are for obtaining current and accurate information used as part of its research or recommendations, and then enumerates a number of factors that the investment advisor should consider and potentially discuss with the proxy advisory firm. Moving on to the fifth FAQ, how should an investment advisor evaluate the services of the proxy advisory firm it retains? How should an investment advisor evaluate material changes in services or operations by the proxy advisory firm? So on this one, the guidance suggests that the investment advisor have policies and procedures that identify and evaluate a proxy advisory firm's conflicts of interest that can arise on an ongoing basis, that the investment advisor consider requiring the proxy advisory firm to update the investment advisor regarding relevant business changes, and the investment advisor consider whether the proxy advisory firm appropriately updates its methodologies, guidelines, and voting recommendations on an ongoing basis. Finally, the last question is phrased as more of a yes or no question, and the SEC proposes here as this FAQ, if an investment advisor has authority to vote proxies on its client's behalf, does it always have to vote on behalf of its client? And the answer on this one is no. The SEC describes two situations in the guidance in which an investment advisor has the opportunity to vote for proxy on behalf of a client, but may appropriately refrain from doing so, may do so without violating its fiduciary obligations to the client. The first is when the investment advisor and the client have agreed in advance to limit the conditions under which the investment advisor exercises voting authority. The second circumstance is when refraining from voting is actually in the best interest of the client. So with that, I will turn it back over to Cliff.
And, Issa, a couple things. We talked about this in connection with Reg BI, should, right? We're talking about a principle-based regulation, the Advisors Act, principle-based statute. But the release is chock full of shoulds. The advisor should do this, should do that, and that hasn't gone without notice by some of the commissioners. So, but what it causes us to have to do as an industry is really look at the release and sort of understand what at least the SEC is saying. Its understanding is what an advisor should be doing.
Absolutely, and to the extent that you decide that you don't want to follow what the SEC is saying should be in your policies and procedures, the practices that you should be following in connection with these particular factual scenarios, you'd probably be well served to kind of make that kind of determination based on the particular facts, circumstances, risks associated with your business, and document the reasons why you aren't following.
Right. If anyone's interested, we did a legal alert, so you could get it from any one of us, or you could just download it from our website. But we have a whole legal alert on the proxy advisor guidance. And with that, I think we're ready to turn to a couple of critical enforcement activities involving advisors.
Thanks, Cliff. So two recent cases we're going to talk about first that have garnered much attention in the industry, and they both deal with mutual fund selections and recommendations. There are certain elements that are similar to other cases that have been brought under the share class initiative and prior to that. The first one is the Commonwealth complaint, and I just, at the outset, I want to make clear that this is a complaint with allegations, so these are alleged violations that have not been yet proven or settled, so at this point they're just allegations. The SEC asserted that Commonwealth received revenue sharing from its clearing firm, Manifest, and that created a conflict of interest, and that conflict of interest was not fully and fairly disclosed. The program dealt with NTF mutual funds, no transaction fee mutual funds, and Commonwealth did disclose that it received revenue sharing in an NTF program. However, the Commission concluded it didn't go far enough, and that's the real crux of the case. For example, the Commission alleges that Commonwealth did not disclose the financial incentives that it had, which were based on which funds it selected or recommended, and that it did have an incentive to recommend funds in more expensive mutual fund share classes when lower cost share classes that paid little or no revenue sharing were also available for the same funds. So in that sense, it sounds very similar to many cases that have been brought previously by the Commission. A lot of the conflict is based on the fact that the revenue sharing either were paid on certain funds and not other funds, or the amount of revenue sharing differed depending on which fund was recommended. The Commission also alleged that Commonwealth did not disclose revenue sharing in connection with transaction fee funds. It had disclosure about MTF funds, but not transaction fee funds. So the Commission alleged that was an omission, a material omission. And also the Commission said, you did not disclose that there were certain funds that did not pay revenue sharing, and that created an incentive not to recommend those funds. So a lot of similarities to prior cases. On the next slide, just some takeaways. Again, the Commission really focused on the incentive created by certain funds paying revenue sharing that resulted in higher expense to clients and worse performance when lower expense funds or lower expense fund share classes for the same funds were available. One of the interesting things that I just note here in the second bullet is that the Commission did not spend a lot of time on this point, but I just wanted to raise it, is that none of the payments, according to the disclosures that Commonwealth had in the ADV that were cited by the Commission, none of the payments went to the reps. They were all maintained by the firm, and that did not appear to have much of an impact on the SEC. It still asserted that they created material conflicts of interest, so I just wanted to point that out. Commonwealth did add disclosure over time and improve that disclosure over time, but the Commission concluded those improvements were insufficient because of the use of potential conflict and the use of may. So this comes, again, follows from the Robert case that we've discussed previously, also comes straight out of the certain language in the Advisors Act interpretive release. So I wanted to mention that. The SEC alleged the normal violations and asked for the normal remedies that are laid out in the last bullet. Moving to the second case, Cetera has certain similar elements to Commonwealth. Again, this is a complaint, and it's just, at this point, allegations by the Commission. So you'll see some of the similarities here. The Commission alleged Cetera breached its fiduciary duty by putting clients in higher cost share classes when less expensive share classes of the same funds were available. Again, it's a failure to disclose based case. The Commission said Cetera breached its fiduciary duty in 4 ways. Number 1, putting clients in the higher cost share classes. Number 2, failing to disclose that it was receiving revenue sharing for certain funds but not other funds. And then there was a second type of revenue sharing for administrative services that were provided, again, that were only paid based on certain funds but not other funds. And the last one is new. That's it's an allegation that Cetera directed its clearing firm to mark up certain non-transaction-based fees that were then passed back to Cetera by the clearing firm, and that was not disclosed either. The next page here, next slide here, is an interesting thing that I've not really seen much before. In addition to saying that the firm had a conflict based on which mutual funds it recommended, because again, only certain mutual funds paid revenue sharing and others did not, the SEC also alleged that the arrangement created an incentive for Cetera to maintain its relationship with its clearing firm. And you see that at least 3 times in the complaint. And to me, that's an interesting assertion on the part of the SEC, but the fact that they said it 3 times suggests that they actually think that does create
in a conflict framework,
in
right?
a conflict framework,
yeah.
that conflict should have been disclosed also.
And they could have said also it was just a failure to disclose. I mean, they could have just said that, and they sort of go out of their way to make that point that you're making.
Yeah. The other thing that really stuck with me with this case was how much emphasis there was on the duty of care compared to the prior cases with similar fact patterns. And there are sentences throughout the complaint which really almost are verbatim from the Advisors Act interpretive release. And I just quoted one here that Cetera failed to use ordinary care under the circumstances, failing to exercise the care that a reasonable investment advisor would use in making a client investment. And you have very similar phrasing and language in 2 other places regarding to failure to adequately disclose, and another failure I think was with respect to best execution. So a lot of duty of care language in this complaint, really taken almost verbatim from the Advisors Act interpretive release. So I think that's just a kind of a signal to the future of what we can expect. The prior cases were almost, primarily and almost universally just duty of loyalty, failure to disclose cases, where this is also a lot of failure to exercise duty of care.
Right.
So I think we're going to see a more healthy balance, if you will, between those two in future enforcement cases. The final point also is something that I have not really seen previously, is that the fact that certain funds paid revenue sharing caused different reps to recommend those funds, where other reps recommended different funds. The SEC, noted, hey, you're treating your clients differently based on when they, came in and when the recommendations were made. And the SEC was saying, we have an issue with that. You have differential treatment of clients, and I haven't really seen that as an emphasis in prior enforcement action. So I wanted to mention that. On the next slide, you'll see it's very similar to the Commonwealth case and many of the prior cases. just that the disclosures were insufficient. Again, use of may, you disclose certain things but not other things. On the fourth bullet point, that's a new point. Cetera had language in its disclosures that said we monitor the activities of our IERs to ensure that what they're recommending and the services and products they're recommending are appropriate for your specific situation. And I think the fact that the firm went out of its way to make that assertion got the attention of the SEC, because the SEC again is alleging that that statement is not accurate, because in fact the firm is only reviewing for general suitability, did not review for an evaluation of whether clients were put in the best share class. And so they went out of their way to reference that. Again, you have the normal assertions and the normal requests for remedies. So those cases have gotten a lot of attention. I'm going to move now to certain cases that have not received a lot of attention, but I think over the next few years are going to certainly get people's attention. The focus, you look at the rulemaking package that just came out in June, and we have a solely incidental release, which really goes to when are broker-dealers acting as investment advisors. And these cases deal with the opposite. They deal with when is an investment advisor acting as a broker-dealer. And today, as you can see from the Commonwealth case, the Cetera complaint, and the whole share class initiative, there's been just tremendous focus on share class initiatives, on share class and revenue sharing, 12B1 fees, other types of revenue sharing, and that's what's hot today. I think this topic has the potential to be what we're focusing on 2 years from now and 3 years from now. And I can see a whole slew of cases being brought in the future based on the same premises, these cases. Why do I say that? Two very big trends that have been going on the last few years. Number one, the movement of assets from brokerage accounts to advisory accounts. That's obviously been going on for 10, 15 years, and everyone's well familiar with that. There's a second trend which is not receiving a lot of attention, which is the trend from putting clients in exchange-traded securities to non-exchange-traded securities. Just a few weeks ago, the SEC proposed harmonizing the private offering exemptions under the Securities Act. And in that rulemaking proposal, the SEC noted how much the percentage is shifting from clients and investors investing in traded securities to private offerings. The very, very significant shift, and that's accelerating. And the SEC rulemaking, if it gets adopted, may actually accelerate that. So we have more and more client money, and including money of investment advisors, going into privately offered securities. And so you take that trend with the more assets moving from brokerage to advisors, and after the Great Recession, we had a lot of academic studies about how you really need to have non-correlated assets, and to really achieve non-correlation, you need to really go into alternatives. So ever since 2010, advisors, because of the Great Recession, have been putting more of their assets in non-traded securities. And all of those trends combined are leading to advisors stepping over the line and acting as unregistered broker-dealers. The most recent case, the first one I'm going to mention briefly, the Foundations case. Brought a few months ago. This is a settled enforcement case against Foundations. And all of these three cases that I'm going to talk about basically have substantially similar fact patterns. You had compensation going from the issuer. In this case was a private real estate fund that was paying essentially commissions and upfront compensation, as well, in this case, trailing fees in addition, based on the amounts clients invested. And the advisor just didn't disclose that to his clients. A clear violation of Form ADV requirements, clear violation of just general fiduciary obligations to disclose all material facts relating to the relationship. And obviously getting paid by the issuer is a material fact. And so that wasn't done. But here I'm focusing not on that, but rather the fact that the SEC said, when you get paid a commission from an issuer, you're acting on behalf of the issuer, again, in this case, a private real estate fund, and that's making you a broker-dealer. And it did not really help the firm that the firm did not charge advisory fees on the assets invested. It only received commission. So there was no double dipping here. The next two cases, you had double dipping, but didn't matter. The SEC brought the action for failure to disclose and brought the action for not registering as a broker-dealer. In the last bullet, I'll just note that the settlement was against both the firm and the principals. Next case on the next slide, Tamara Steele, Steele Financial, late last year, very similar fact pattern. The firm and the principal, again, received compensation from an issuer that paid the firm and the principal commissions. They did not disclose that. That led to the fraud charges, also led to the charge that the firm was acting as an unregistered broker-dealer. In this case, the commissions were based only on a percentage of the amounts invested by the clients. And again, the complaint said the payment of this money turned the defendant into an agent of the issuer. And that's what led to the broker-dealer charge. The next case, also from last year, very, very similar fact pattern. Here, the defendants were really being paid to raise money for 4 different private placements. And they were doing all sorts of very bad things that I won't discuss in any kind of detail. But that led to the fraud charges and also the charge that the defendant was acting as a broker-dealer. Just a couple of things I'll mention, that the firm entered into agreements that were called finder's engagements, placement agency agreements, etc. And the firm really promoted the securities on behalf of the private companies, and you had the normal remedies requested by the commission. So the common theme here is that the receipt of compensation from an issuer turns the advisor into an agent of the issuer, which in turn turns them into a broker-dealer. And essentially, the firms went from representing their clients to really representing the issuers. On the next slide, just a couple of takeaways. That there is no advisor exclusion from the broker-dealer registration obligations in Section 15 of the Exchange Act. We are all familiar with the solely incidental exclusion for broker-dealers from the definition of investment advisor, but there's no corollary exclusion for advisors from being excluded from the definition of broker-dealers. If an advisor receives commissions or any sort of transaction-based compensation from an issuer, you had that question, are you acting as a broker-dealer? I think these cases really bring that risk to light. You should check your ADV disclosures. What do you say in them, in your ADV about how you get paid? What do you do for that compensation? Who do you get paid by, et cetera? Also, marketing materials, websites, et cetera. You want everything to be consistent. If you do get that compensation, at the very least, you have a disclosure obligation as a fiduciary, as set out in the Advisors Act Interpretive Release, to disclose that conflict of interest. But that disclosure, even if you have it, is not going to cure the broker-dealer registration obligations if it exists. So this is not something you can cure via disclosure. If you enter into an agreement with an issuer, you need to be very careful. And folks may be asking themselves, well, why would an advisor enter into an agreement? If it were up to me, I would probably not enter into an agreement with an issuer. But one has to recognize certain practical, the reality that under the AML no action letter that the SEC issued to broker-dealers, if an advisor has a relationship with a client that a let's say an issuer has a dealer manager or placement agent, that dealer manager or placement agent is not going to know your client, but you know your client. So that broker-dealer may rely on you pursuant to the SEC no action letter that was granted to SIFMA that allows broker-dealers to rely on advisors to help the broker-dealer satisfy its AML due diligence obligation. That broker-dealer may ask you to make certain representations, and they may want that in the written agreement. Similarly, pursuant to no action relief granted under the 33 Act many years ago that allows issuers to rely on investment advisors to determine that an investor is a accredited investor, and now that's built into Rule 506C of Reg D that allows investment advisors to confirm that someone is an accredited investor. An issuer may again want a written agreement with an advisor saying that, hey, advisor, is your client an accredited investor? We want some reps and warranties from you. So there are actually legitimate reasons to enter into an agreement with an issuer, but you need to be very careful that there's nothing in that agreement that is going to turn you into an agent of the issuer in connection with the distribution of the issuer securities. That's the bottom line.
And even sometimes those agreements could be entered into on behalf of a dual registrant, and it speaks to, let's say, the receipt of 12B1 fees, but the agreement says that the 12B1 fees are to be received by a broker-dealer for the following activity.
Right.
You want to make sure it gets to that broker-dealer and those following activities are done.
Right. And if that 12B1 fee is for distribution as opposed to servicing, then you need to treat that activity in that agreement as broker-dealer activity.
That's right. That's right. And I would say this discussion we just had a few years ago just was not like the focus is so much more intense than it was a few years ago by the SEC.
Yes. And now that they brought complaints and have a settled case, again, go back to what I said a few minutes ago. The trend of assets going into the advisor space from the brokerage space, and the trend to invest in alternative assets, whether it be non-traded REITs, whether it be a hedge fund, private equity fund, real estate fund, BDCs, et cetera. These cases this is going to happen more and more just because of the large amount of assets moving over. It's going to happen.
Right. Hey, Ben, we're going to get to you in 30 seconds, but we're going to give the CLE code. It's a pretty good code, by the way. Yeah, for those of you who'd like to receive CLE credit for today's webcast, our confirmation code is guidance. So again, please use the confirmation code guidance. Use this code for the sign-in sheet available for download from your viewing console. And that takes us to Ben Marzouk to go through some of the OCIE risk alerts.
Yeah, thanks, Cliff. So there were 2 risk alerts issued since we last spoke, and both issued by the SEC's Office of Compliance Inspections and Examinations, otherwise known as OCIE. The first risk alert you see here, which was issued on July 23rd, focuses on observations from OCIE's examinations of advisors, in particular the compliance, supervision, and disclosure of conflicts associated with an advisory firm that currently or previously had employed individuals with certain disciplinary histories. So OCIE basically conducted a series of targeted examinations focused on IAs that had employed individuals with a history of disciplinary events. The examinations were all part of a broad supervision initiative announced by OCIE actually in September of 2016 through a separate risk alert. And as part of this initiative, the SEC conducted more than 50 exams of advisors in 2017. So as I mentioned, these exams were targeted, and the SEC was able to zero in on the firms that had employed individuals with prior disciplinary histories based on Form ADV disclosures and other information as well. So the exams broadly focused on 3 areas that you see here on the slide: compliance programs and supervisory oversight practices, which basically includes policies and procedures, and that's usually an easy way for firms to get hit with deficiencies if they're not adequate or the firm isn't following the procedures. And then also disclosures, so generally full and fair ADV disclosures, and also marketing materials were mentioned. And then third, finally, it focused on conflicts of interest, which including ADV disclosures of the same conflicts. Moving on to the next slide, the SEC's first observations related to the firm's direct supervision of individuals with disciplinary histories. And one thing they noticed was that almost half of the disclosure-related deficiencies cited in the exams were due to firms providing inadequate information regarding the disciplinary events. As background, Form ADV requires all advisors to promptly disclose certain legal or disciplinary events that would be material to a client's evaluation of the investment advisor. And what the SEC noticed was that firms were omitting disclosures of disciplinary events, and these omissions oftentimes occurred because the firm was relying on the supervised person to self-report the disciplinary events. And the SEC seemed to suggest that relying on self-reporting was not sufficient, and firms had to proactively search for this information for new hires. Another deficiency related to incomplete information. So this would be, didn't include the date of event, the total number of events, the allegations, any fines, judgments, or rewards, or other sanctions imposed on that supervised person. Separately, another observation by the staff was that many advisors did not adopt or implement compliance policies and procedures addressing risks associated with hiring and employing individuals with prior disciplinary history. One area where the SEC found deficient procedures was related to self-attestations from the supervised persons. as the firms did not have procedures to proactively determine whether the self-attestation was actually accurate. The procedures essentially ended at receiving the self-attestation and didn't take any additional step to check or verify that information. And this appears to be one of the key takeaways from this OCIE alert, that, to the extent that the advisor just accepts the attestation without any confirmation or verification, you should consider revising the policy to check for accuracy of this statement. Moving on to the next slide regarding firm-wide practices. After focusing on the individuals with disciplinary histories, the SEC's observations then transitioned over broader firm-wide practices. So these findings went beyond the hiring of supervised persons with disciplinary events and focused more on firm-wide culture. So regarding supervision, OCIE found that many advisors did not establish appropriate standards of business conduct for their supervised persons. Examples of this insufficient supervision included clients paying for certain services they never received, allowing supervised persons to prepare own advertising or marketing materials without adequate advertising policies, and then also failing to review activities of supervised persons working from remote locations or through a geographically dispersed area. Regarding policies and procedures, the SEC observed that many advisors had adopted policies that were not consistent with their actual business practices. And this was mentioned briefly earlier. It's not enough to simply have the policy on record. And as we've discovered, many advisors didn't even do that. But once you have it on record, the firm must actually adhere to it. So the areas of inconsistency cited by the staff, where the written procedures really didn't match the practice, included commissions, fees, expenses, solicitation fees, management fees. So really, this kind of zeroed in on the firm's compensation practices. Finally, the SEC touched on firm-wide compensation arrangements. They noted generally that several advisors had undisclosed compensation arrangements which resulted in conflicts and could have impacted the impartiality of the investment advice given. As examples of this, OCIE pointed to forgivable loans given to supervised persons that were not adequately disclosed. So these loans are typically structured on certain client growth targets, which may influence the investment decisions made by the advisor. And this is something in the SEC's view that they would want full and fair disclosure of to the customer. Moving on, the next slide focuses on staff guidance on ways to improve, right? So after citing all of these deficiencies in the exams, the SEC finally offered up some practical suggestions for firms to improve their compliance programs. For instance, the SEC suggested firms adopt policies and procedures specifically covering what must occur prior to hiring persons with disciplinary histories. Most of the examined advisors actually had these policies and procedures, and the better ones actually required investigations of the disciplinary events and determine whether the individual was even eligible to qualify for a securities license. The SEC also suggested enhancing due diligence practices, especially associated with hiring persons with prior disciplinary events. So this would include conducting background checks, employment history, financial and credit information. The SEC did note that the failure to even disclose prior bankruptcies was actually a common deficiency they found from firms. Also conducting internet and social media searches, fingerprinting personnel, third-party research firms, contacting personal references, and verifying educational information. Those are all methods of conducting better due diligence. Another good method firms should consider would be just requesting a copy of the individual's Form U-5 if they've been terminated by another firm. So that covers the first OCIE alert. Moving on to the second one was just issued a couple weeks ago on September 4th and covers principal and agency cross-trading compliance issues for registered investment advisors. So the alert covers OCIE's observations of the deficiencies from exams of investment advisors over the last 3 years. They didn't say how many, related to principal trading and agency cross-trading. And just as background, because it can get relatively confusing, and firms were even confused by whether they were engaged in the activity to begin with, principal trading restrictions are covered by Section 206(3) of the Advisors Act. And it makes it unlawful for any advisor, directly or indirectly, to act as a principal for his or her own account and knowingly either sell any security to an advisory client or purchase any security from a client in that capacity without first disclosing to that same client in writing the capacity in which the advisor was acting and obtaining consent of the client to such transaction. So that's essentially principal trading, and it operates to prevent unauthorized or at least undisclosed self-dealing by the advisor. And as for agency cross transactions, these restrictions are also covered by Section 206(3) of the Advisors Act and Rule 206(3)-2 under the Advisors Act. And this covers advisory activities when acting as a broker for both the client and the other party to the transaction. So it essentially prohibits an advisor, either directly or indirectly, from acting as a broker for a person different from the advisor's own clients, and then knowingly affecting the securities transaction for the account of that same client without first obtaining or without first disclosing the capacity and obtaining the client consent, very similar to principal trading in that regard. Note that Rule 206(3)-2 does provide some limited exceptions to the general prohibition against agency cross trading, particularly when the client has executed written consent prospectively and written confirmation and an annual written disclosure summarizing all the agency cross transactions are provided to the client. Finally, I just note that the SEC pointed to the recent investment advisory interpretive release offered as part of the SEC's Reg BI rulemaking, and said that the disclosure and consent may not be enough, that the disclosure must be robust, full and fair, and provide information that would alert the client to any potential conflict of interest. So essentially a heightened or more material disclosure obligation. Moving on to the next slide, where the SEC identified some deficiencies in this area. So common deficiencies cited by the staff, most prominently the SEC observed that the basic requirements of 206(3) were not being met. Examples of this included advisors just not being aware that the transaction was in fact a principal trade. And then some investment advisors recognized that it was in fact a principal trade, but failed to obtain client consent or failed to provide the adequate disclosure. Another common deficiency cited by the SEC was principal trades with pooled investment vehicles. So OCIE observed that investment advisors engaged in these principal trades with pooled vehicles did not adhere to Section 206(3). And this included IAs affecting trades for pooled investment vehicles but failing to recognize their own ownership stake in the vehicle. So that's obviously a problem if you have an advisor and an advisory a client and affecting transactions between the client and the affiliated pooled investment vehicle where the investment advisor owns a stake in the pooled vehicle. Moving on to the next slide, which covered some common deficiencies with agency cross transactions. OCIE also found deficiencies related to agency transactions, including where advisors affirmatively disclosed to clients that they would not engage in any agency cross transactions, but in reality they actually did. I'd also point out that OCIE found that many advisors did not have adequate policies or procedures related to 206(3) covering these principal or agency trades, even though the advisors were in fact engaging in the transaction. So, and although this probably goes without saying, if you are engaged in the activity, make sure to adopt policies and procedures covering that activity. So with that, I'll hand it back to Cliff.
Thanks, Ben. We appreciate it. And Hanna, we're going to turn to you in the UK. Hanna Jones, our colleague in the UK. We all have a lot of questions about what's going on there, but for purposes of this, we want you to talk about the FCA's asset management market study. So you on, Hanna?
Yeah. Hi, Cliff. Thank you.
How are you?
I'm going to keep it just to the asset management market study today, so I won't mention anything about the dreaded B word. I wanted to give a quick update on where we are at the moment with the market study in relation to benchmarks, investment objectives and policies, and overall value assessments. When I last spoke to this group about the study, we were deep into the review process, but now the first deadline has come and gone, and we're now on to the next phase. So as a brief reminder, the first deadline was the 7th of August this year, and by that date, asset managers needed to ensure that any use of benchmarks was set out in the relevant funds prospectus to enable them to continue using and referring to benchmarks and other marketing materials. So really this is around a consistency exercise to make sure that the prospectuses were the golden source for that material. And this has been a significant project for many clients. So every investment objective and policy has had to be reviewed, and that's been into the hundreds just that we've seen at this firm, and in very short timescales to establish if a relevant benchmark should be disclosed. So although in the pipeline for some time, the 7th of August deadline triggered a wide-scale review of investor-facing and marketing materials, as well as internal agreements, and that involves substantial resource within clients and at the FCA. And for the most part, we've seen existing disclosures updated to reflect current practice. However, some updates have been more detailed than perhaps was initially anticipated, and this means that some fund details now have a different look and feel, albeit nothing has really changed in practice. But as with many regulatory change projects, there's little time to take stock, and firms are now having to turn their attention to the next points that I've mentioned on the slide. So the first one is looking at more thorough investment objective and policy clarifications, unless they made those changes as part of their benchmark updates, and then moving on to overall value assessments. So taking investment objectives and policies first, projects are now underway to rewrite existing disclosures so that they're clearer for investors and enable investors to more easily compare funds across the industry. And some key themes here include, firstly, making it very obvious whether a fund is an actively managed fund or whether it's a passively managed fund. And that was something the FCA picked up on, that it's not clear to investors necessarily at the outset. And it's not simply enough just to say that a fund is actively managed or to say that it's passively managed, but you need to go further than that and explain to investors what that means. Secondly, another theme is including detail on the investment strategy employed by the investment manager. So, for example, if there's a focus on a certain sector, a certain geography, or a certain type of risk. And also removing the flexibility to invest in asset classes which are not relevant. So a lot of funds in the UK which are old, which were approved by the FCA a time ago, they've got a lot of legacy language that perhaps hasn't been updated, which permitted flexibility to invest in any other type of asset. And that's no longer accepted by the FCA, and it's no longer permitted within the documents. So this means that what we're seeing from the FCA is that the previous argument that could perhaps be used about this has been approved by the FCA in the past no longer works. And the approach that you need to take now is to consider what the FCA is looking at in the current space. And another theme from this is describing strategies such as efficient portfolio management and other uses of derivatives to try and make that very clear to investors as well, so that the risks of those strategies are known. And this project doesn't just involve the fund prospectuses and investor-facing documents. What we're seeing is that firms are having to look back at their investment management agreements with their managers and advisors to make sure that they're consistent, and discussing positions with the managers to make sure that the language used is understood in the same way by all parties. So what we've seen is that the documents might say one thing to an investor, but take it back to the investment professionals, and they have a different language, and these things can sometimes mean different positions. So what we're seeing is that some firms are coming up with guidelines and internal glossaries that are used throughout the business so that everybody's singing from the same hymn sheet. I think it's probably worth saying that this has been met with some pushback from firms, as you can understand, and there's not a lot of appetite to look back at past investment management agreements where these have already been approved, signed and in place and working well for a number of years. But our sense in the market study and our experience with the FCA is that it's no longer possible to have generic, flexible, permissive language within these documents. And if that means that these do need annual reviews and that they need to be updated on an annual basis, and that has to be the case. And there's no set deadline from the FCA to complete these rewrites. So the FCA is at the basis that this guidance existed before the market study came out. So they're not looking for anybody to meet a certain deadline. Their view is that actually this should already be the case. But that being said, some firms have given the FCA a proposed timeline or a project schedule that they're now working to. And in addition to the work from the FCA, what we're also hearing is rumblings from the Luxembourg and Dublin regulators about similar projects to seek clarification on investment objectives and policies for funds in those jurisdictions as well. So this might look like something that has kind of been initiated here, but that flows out to Luxembourg and Dublin. So that's something that we're also keeping an eye on. And the last point I wanted to note is the new requirement to prepare an overall value assessment. So as part of the earlier market study consultation papers that the FCA put out, they looked at value for money and whether consideration should be given as to whether the cost of a product is justified. And this really goes to the point of the authorised fund manager being the agent of the investor, and being in such a position means that it should be able to control the costs that investors are subject to, as they're not in a position to be able to do that themselves. However, the position moved on in later documents, and the final rules that came from the FCA require an authorised fund manager to conduct an assessment for each fund that it manages, but on a class-by-class basis, of whether the payments that are coming out of the scheme property are justified in the context of overall value, so not just cost. So this clearly goes further than considering just the cost of a product, and the FCA noted in its papers that this is closer to the Gartenberg principles that you have in the US. However, although there are similarities between the UK and the US, it's not possible to apply the same principles and reporting across the UK and the US, as there are some differences that we need to consider. And firms will need to publish the results of their assessments in the reports and accounts or some other form of composite report. And we're already seeing clients start to prepare these as the new rules are in effect for any accounting period ending from Monday. So in terms of what needs to be considered, the FCA has prepared new rules setting out the minimum requirements which must be taken into account. And the FCA do note that additional requirements can be taken into account and considered by managers, provided that they explain these factors to investors and consider the factors that are set out in the rules at an absolute minimum. And just to touch briefly on what some of those requirements are. So the minimum requirements from the FCA are a consideration of the range and the quality of the services being provided to unit holders, the performance of the fund after the deduction of all costs, and consideration of the performance of the fund over a certain type of period. So if the fund is proposing to achieve a certain return over a certain period of time, that the performance is measured over that period of time. There's a need to consider each charge coming from scheme property, including costs that are paid to third parties and the authorised fund manager. And a consideration also about whether economies of scale can be achieved, and if economies of scale can be achieved, whether or not they can be passed on to investors. In addition, a couple of the ones that we're seeing are being quite tricky for asset managers is a consideration of each service provided in the market and whether comparable services, whether there are comparable market rates for that, so looking at the services provided by the authorised manager and any delegates, and looking really at whether the cost of those services should be lower or there are people in the industry who are providing those services at a lower cost, but they're comparable services. And also a consideration of the charges that the authorised fund manager and any of its associates, so anybody else in its group, those charges that they make for comparable services provided to different clients. So the FCA has put a real focus on the fact that it's not just your retail investment funds that you should be considering here, but as part of a mapping across the group, what you should be doing is looking at if you've got a segregated mandate where the cost is much lower, but actually what the investor is getting is very similar to what a retail investor has in an investment fund, then you need to look at whether the difference in cost between those two investors is justified. And then also looking at whether investors should be moved into cheaper classes if the only difference between those classes is the charge that the investor pays. And the reports and accounts need to detail the discussions and the process and the explanations for each of these minimum requirements, in addition to any other factors that the manager considers. And they also need to include a conclusion as to whether charges are justified in the context of overall value. And if it's discovered that actually there isn't, those costs aren't justified, then the manager needs to make clear what action has or will be taken to address the situation. Now, at the moment in the UK, there's not a lot of meat on the bones yet, I think it's fair to say, and we think that the approach will be certainly a less is more approach until a few reporting cycles have been completed. And as I said, some points do require detailed mapping for firms, so for example, the comparable services provided within groups, and this is going to take a lot of time and a lot of resource again. And the Investment Association over here has prepared some papers to try and provide further guidance, but at the moment we're really waiting to see if the industry adopts a kind of a template approach, albeit from what we know with our experience of a number of firms, they will like to put their own mark on those reports. So for the moment over here, it's a bit of a watch this space on the overall assessment. And so back to you, Cliff.
Great. Thanks very much. We appreciate you joining and providing that. So with that, and I know we're after the top of the hour, we're just going to run a couple of more minutes, but we're mindful of the time. We're going to take a couple of the questions that came in, and then we're going to wrap up. And the questions really deal with the enforcement activity that we discussed. So Michael's going to take the first one.
So the first question related to the foundation set of cases when advisors are giving advice with respect to privately offered securities. The question is, were those actions based solely on the revenue being received from the issuer or its advisor? What if there was no compensation paid? It's a great question. That's the receipt of compensation from an issuer for distributing their securities is clearly the primary driving force behind those cases. And any time an advisor, as I said before, is receiving transaction-based compensation from an issuer, it really needs to think long and hard about whether it needs to be registered as a broker-dealer. But let's take that off the table. Let's change the facts and say, what if the advisor was just charging its a normal advisory fee? So two things. Number one, an advisor can give advice to his clients on any security. So an advisor, there's no issue for an advisor to give advice on a privately offered security versus something that's exchange-traded. That being said, and this is my second point, is you want to make sure you don't turn yourself into an agent of the issuer in connection with the distribution. And that's why on one of the slides I talked about be very careful if you enter into an agreement with an issuer. Because what you don't want to happen is you don't want to have language in that agreement that says you're going to offer the securities, you're going to sell the securities, you're going to place the securities, you're going to distribute the securities, or anything that says that you're an agent of the issuer in connection with the distribution. Because even if you don't have a discrete commission paid by the issuer, you're basically asking the staff to find some economic benefit that is running from the issuer to you. And that benefit could be an award of a warrant, it could be a non-cash benefit, it could be the issuer picking up certain operating expenses of the advisor, it could be the issuer providing various services and no cost to the advisor, like back office support services. So I wouldn't just focus on the payment of compensation. I would also, I guess, broaden the question to ask, are there any economic benefits, broadly speaking, flowing from the issuer to the advisor? Because if there are, I think you still have an issue that you need to grapple with.
Great. I'll take another question that came in quickly, and it has to do with the duty of care. Do we expect to see that playing out in future actions and greater reference? And so what we're talking about, the starting point is an advisor owes a duty of care and a duty of loyalty. Over the years, duty of loyalty has gotten a lot of attention. The duty of care has always been out there, but we saw it really play out in the fiduciary interp. And as Michael noted, in the Cetera action, we're going to continue to see that. We're going to continue to see it in enforcement action, but we'll also see it as part of examinations. And again, it's very much a focus of the SEC, and I think there is a Reg BI corollary to that. But again, this duty of care is not isolated to the Cetera case. And we have one more question.
Sure, and this question relates to the Commonwealth case and asks if Commonwealth, let's say, hired a sub-advisor to make the selections of the funds such that Commonwealth did not know what funds were paying revenue sharing, do you think that would have made a difference? And logically, I would say the answer ought to be yes. Having said that, we did represent a couple of clients as part of the share class initiative that hired a sub-advisor to make the selections, and the commission still said to our client, the advisor that hired the sub-advisor, you have an issue, you need to disgorge your profits, and we'll treat you like everyone else. And I think the theory of the staff was, if you're hiring the advisor and you have revenue sharing coming back to you over a period of time, you can't take the position you don't know about it, you had nothing to do with it, it's just, some other firm that's making the decision. So the staff disagreed with us, but I agree with the point, and I think logically, if you don't have control or over that decision, you shouldn't be, you don't have a conflict. The staff says, however, if you hire someone else, you do have the necessary control, and it is something that you're not in a very different position. So I think there's this tug of war going on that issue. It's a very, very good question, and let's say to be determined, hopefully, at a later point in time in the correct way.
Great. All righty, so we'll wrap up. Before we wrap up, next quarter, we'll be doing it again. Here's the agenda. The advisors' rulemaking. The advisor advertising rulemaking. That seems like very likely in the next month or so. Maybe FAQs for the CRS and maybe a solicitor rule proposal. So we'll see. So a lot to come next month. Thanks everyone for joining us today. As a reminder, if you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And again, the code was guidance. Should you have any questions or if you'd like to request a copy of the slide deck, please contact any one of us and we'd be happy to send it to you. And with that, we'll see you next quarter. Take care, everyone. Bye-bye.